Today we will discuss about copyright protection in Italy. So our analysis of the protection that is given to the copyright works in the Italian territory. According to Section 1 of the Italian copyright law, a number of works of art are protected in the Italian system. Literary works, for example, but also works of music, graphic arts, theater. And recently, the protection has been extended to the so-called useful works, meaning computer programs, databases, and industrial design. For databases and industrial design, specific exceptions apply. In other words, databases are protected as far as the selection of the data are the expression of a choice of the author. And with reference to industrial design is protected only if it has an artistic value, which is something different from many other jurisdictions in Europe. The case law and the doctrine consider the list provided for by Section 1 of the Italian copyright law non-exhaustive, meaning not only the works of art that are indicated in that list can be protected, but also works such as TV format or fantasy character or museum or multimedia works can be protected as work of art. What is necessary is that the work is an expression, is a non-trivial expression of an intellectual effort of the author, and that is new and original. As in many other countries, in Italy, copyright does not protect the idea behind the works of art. What is protected is the form of expression. This is a very established principle, it's called idea-expression dichotomy, which is known also to many other jurisdictions. Again, as in many other jurisdictions, in all the countries which are part of the Berne Convention, in Italy there are no formalities, no formal requirements to access to copyright protection. In other words, the protection is granted as far as the work is created, and for the same fact that the work is created. No publication is required and no registration is required. The Italian Collecting Society, CIAE, has a registry of the copyrighted work in Italy, and this is used by some of the authors to get some evidence of the fact that the work has been created at a certain time, and there is also the assumption that the person who registered the work is the author of the work. So in case of litigation, registration can be useful, but it's not necessary. The duration of the copyright in Italy is, as in many other countries, 70 years after the death of the author or of the co-author if there is more than one author. Neighboring rights have a shorter term of protection. DLA Piper has a strong experience in the copyright field, DLA Piper Italy, both in the transactional and in the litigation area. With more of 400 IP lawyers worldwide, we benefit of the presence of our colleagues in other jurisdictions to provide the clients with a coordinated service. Please stay tuned on Lawyers Monday to know more about copyright protection in Italy.